Welcome to This Explainer. Today, we're looking at a deeply complex issue, the gap between what sexual assault survivors expect from the justice system and the reality they actually face. It's a fractured path, honestly. We're going to impartially examine a situation filled with intense emotions, totally different perspectives, and some massive systemic challenges, from the very first moment evidence is collected right down to the emotional toll of the courtroom.
Let's start with a quote that really hits hard. A 15-year-old survivor asked this: "Why did I put myself through the pain of going to court, going through a trial, reliving everything? It sort of gave me this sense of what's the point?" That right there, that question, perfectly anchors the emotional stakes of everything we're about to unpack. It really highlights how a system designed to deliver justice can leave the people it's supposed to protect feeling entirely unsupported and disillusioned. To really grasp the scale here locally, let's look at a specific number: 250. In just the bailiwick of Guernsey, 250 sexual offenses were reported in 2025 alone. That includes 69 rapes and 67 sexual assaults. And, advocates are quick to point out that this is likely just a fraction of the real story. Think about it. In a small community where you might literally know the police officer at the front desk, walking in to report an assault is incredibly daunting. Because of that extreme vulnerability, a lot of cases just never get reported.
So, what is that first major hurdle on the path to justice? Well, it's forensic evidence. Right after an assault, victims are obviously in a state of profound shock. But the formal process, it demands that they step into a clinical or police environment right away for a highly intrusive evidence collection. For someone who has just had their autonomy violently taken away, having to navigate a formal system with so little personal control can feel like an absolutely impossible mountain to climb.
And that brings us to a proposed solution that's sparking a ton of debate. Rosalie van Zutphen, an advocate and survivor, is pushing for at-home DNA self-swab kits to be distributed in the Channel Islands. Her take is pretty straightforward. She says these kits give another option to survivors. The idea is that a victim could discreetly take a swab at home, secure the DNA, and then take a breath. They get time to figure out their next steps without being forced into an immediate, traumatizing trip to the police station.
Now, this debate really lays out two totally contrasting perspectives. On one side, advocates argue these DIY kits offer crucial discretion, privacy, and most importantly, give victims time to choose. But on the flip side, official authorities strictly mandate the use of formal police channels and sexual assault referral centers, or SARCs. Their reasoning? They argue these official routes are specifically designed to offer holistic, trauma-informed care and, critically, ensure the evidence collected is completely legally sound.
And that is exactly where the friction hits. The push for DIY kits has faced some seriously uncompromising pushback from legal, medical, and law enforcement officials. We're talking Guernsey's chief legal advisor, the police, and top forensic experts. They all strictly align with national guidance warning against these kits. In fact, official sexual assault referral centers have even called the promotion of these self-swab kits deeply problematic and potentially harmful.
So why are officials so against this? Well, they base their warnings on a few key factors. First off, they argue that using a kit in an unregulated environment risks the integrity of the whole investigation. Second, the National Police Chiefs Council explicitly states that asking a victim to collect intimate evidence on their own places an unfair burden on them right in the middle of a crisis. And finally, forensic experts like Dr. Alex Gorton point out that these kits hold very limited evidential value. Anyone trying to use them in court would face a massive uphill battle, which officials argue just creates highly damaging false expectations for survivors.
What we're left with is this massive expectation gap right at the starting line of the legal process. Advocates are desperately trying to offer another option for victims who are just too terrified to use the intimidating formal system. But authorities are warning that those very alternatives are basically false hope because they lack the weight needed to actually secure a conviction. It's this deep systemic fracture where both sides are ostensibly trying to help the survivor, but they are completely at odds on how to actually do it.
Okay, but let's say a survivor does overcome that first hurdle. They push through the shock, they skip the DIY kits, and they go through the grueling formal police channels to get that legally sound evidence. What actually happens when their case finally makes it to the courtroom?
Well, the courtroom introduces a whole new, often heartbreaking gap between what a victim expects as justice and the strict legal standards applied by judges. Even when you have formal evidence and a completed trial, the sentencing phase frequently exposes a huge disconnect. There's the survivor's moral expectation for accountability, and then there's the complex, rigid framework the law actually uses to hand down a punishment.
We saw this legal reality crystallize in a recent high-profile case. Judge Nicholas Rowland spared 2 teenage boys from jail after they raped a 15-year-old girl. His reasoning? He stated a desire to avoid criminalizing the very young boys. Now, from a strictly legal standpoint, he's applying guidelines around youth offenders and rehabilitation. But we have to look at how that legal rationale actually translates to the victim.
And the translation into the survivor's lived reality is pretty brutal. Reacting to the judge's reasoning, the 15-year-old survivor said, "It almost made it seem as if what the boys did was not okay, but it was okay in the eyes of the law because they were still children." She felt that by sparing her attackers prison time to protect their futures, the justice system essentially minimized her trauma. To her, it felt like the assault was legally validated just because of the perpetrator's ages.
And that brings us face to face with the compounded emotional toll this entire judicial process places on survivors. It's not just the horrific trauma of the assault itself, it's the layered, ongoing trauma of navigating a system that demands immense vulnerability from you, but then frequently delivers outcomes that feel inherently unjust to the victim. To summarize this devastating journey, the reality often starts with a shock so profound it stops victims from reporting at all. And in a small community, that vulnerability is amplified tenfold. If they do report, they face these grueling trials where they are forced to publicly relive their worst nightmare. And at the end of it all, they might face sheer dismay at lenient sentencing frameworks that prioritize the offender's age over the victim's pain. The cumulative effect is just a profound feeling of being totally unsupported by the very system built to serve justice.
So as we wrap up this explainer, we're really left staring at a deeply unsettling paradox. If formal, official procedures feel like an unfair burden to a victim in crisis, but private alternatives are deemed legally useless false hope, and if surviving a grueling trial only leads to outcomes that leave victims asking, what's the point? Then how do we fundamentally bridge this systemic gap? It's an absolutely crucial question that the legal system, advocates, and honestly, society as a whole must urgently reckon with if this fractured path to justice is ever going to be truly repaired.